Mr. Maleka, are you ready to update me on the discussions?
Yes, Chair. We have had a fruitful discussion with our colleagues, and we have reached some sort of accommodation. First, Chair, we would like to place on record that all of them or their clients have received statements which implicate or may implicate them. Secondly, we have finished a bundle of evidence documents which will be canvassed by Mr. Maseko in the course of his oral testimony to all of those who will be implicated or may be implicated by his evidence. We have undertaken to finish similar bundles to those who may well be implicated by the evidence of Ms. Mentor and also Mr. Jonas by latest Wednesday morning. We have confirmed with our learned friends that they will be entitled to attend, be present, and listen to the oral testimony as and when those witnesses testify. They will apply at a moment convenient to them, to you, regarding the privilege of cross-examining any or all of those witnesses. It is not clear to us when that application or those applications will be made, but that's a matter which will engage them rather than us. Chair, we have also indicated to them that we have a timetable setting out the dates when each of those witnesses will testify. To the extent possible, we will rearrange the timetable concerned to accommodate the presence of our learned friends to listen to the evidence of those witnesses. But if we can't, and it's impossible to rearrange, having regard to the prior arrangements we have made with those witnesses, then we will immediately make available the transcript of the evidence of those witnesses so that they are aware and know what was said about and concerning their clients. That is as far as matters are at the moment, and I hope that I have correctly reflected the arrangements we have made with our learned colleagues.
The part that I may be concerned about is a rearrangement of the program in circumstances where they accept that even if the witnesses testify in their absence, they will have access to a transcript and would therefore, if granted leave to cross-examine, not really be prejudiced in any way by not having been there. So that's the part that concerns me, because I would like us to stick as far as possible to the existing plans and program. So that's what I mentioned. Maybe they might, either they or one of them may just confirm that that's the arrangement, but also maybe might wish to say something in regard to what I've just said. Maybe before he does, I say he because I think it's all his. Maybe before he does, Mr. Maleka, do you want to say anything about this remark I've just made about?
No, Chair, we will be guided by the directions you made. After all, you are in charge of the proceedings. I accept that there won't be any prejudice if they have access to the transcript of the evidence immediately. But evidence being what it is, people want to see the witnesses and test their demeanor, but that's a matter that they should address you rather than me.
Yeah, no, I accept that. But as you will recall, my discussion with them in chambers, they immediately accepted that they didn't want to cause any delays, and provided they could have access to a transcript, they would not be prejudiced. Mr. Helens, I'm sure, will confirm.
Thank you, Chair. I confirm everything that Mr. Maleka had to say. With regard to being present when the witnesses gave evidence, we do not go back on either what I said from this podium or to you in chambers. The thought was, though, that it would be hugely beneficial for us to see the witness give evidence, because you don't see demeanor, you don't see pause, you don't see a look of worry or a look of joy, you know what demeanor is, on the face of a witness. So not standing on that principle, but suggesting that if it were no major disruption to the program, and we did hear that maybe one witness wouldn't be available on one day and they might have to change the program for reasons not bearing on our needs. If we could be accommodated, that would be nice. But if we can't be, because it is a disruption, then so be it. But if it can be, because it's something that partly was happening anyway, then we would gratefully accept being present. That's our arrangement. For the rest, Mr. Maleka is entirely accurate.
No, thank you very much. That arrangement is approved subject to the remark that I made. If in the process there might, if the legal team for the commission thinks that in a particular case it might just be a slight adjustment that wouldn't cause much disruption, they can talk to me, and if I'm satisfied, I can approve. But I would really like to keep the program as is. But as I say, where really it's just a slight adjustment, and then there would be an accommodation, we'll look at that. But I wouldn't like any serious disruption of the program. Okay, thank you. I have therefore approved that arrangement in respect of the parties whose counsel placed themselves on record here earlier on. Thank you.
Thank you, Chair, for your direction.
I don't know whether I should say Mr. Maleka or Mr. Pretorius or Ms. Norman, or is it Ms. Norman? Thank you.
Thank you, Mr. Chairman. As my learned friend, Mr. Pretorius, has indicated, mine is to really place some documents before you. I start off by just confirming what the chairperson has already alluded to, that in terms of the terms of reference, this commission, in doing its work, it has to be guided by, amongst other things, the Public Protector's report, and also the case that the chairperson has already referred to. In its judgment, and in particular paragraphs 132 to 140, the court in that judgment, which is the South Gauteng, the Gauteng division, in the President of South Africa versus the Public Protector case, in paragraphs 132 to 140, the court dealt with the truth-finding nature of a commission of inquiry, as pronounced by the Constitutional Court in the various decisions mentioned in those paragraphs. The court also confirmed in paragraph 140 of its judgment that a Judicial Commission of Inquiry is by its nature preeminently suited to carry out the task of investigating the allegations of state capture contained in the Public Protector's report. The Public Protector herself had recommended that there be further investigations through this body. That therefore means that this commission is at liberty to find the facts wherever they may be in order to fulfill its mandate as provided for in the terms of reference. Before you, Mr. Chairperson, I'll be placing documents which I regard as compulsory documents, compulsory foundational documents. And those documents would be, as mandated by paragraph 1 of the terms of reference, would be the Public Protector's State of Capture report and the judgment that has been referred to, which are referred to as the guideline documents. It is therefore, in our view, imperative that those two documents be placed before the chairperson formally to fulfill that term. I will do so shortly, but before I do so, I need to bring to the attention of the chairperson that there are other reports which have been brought to the attention of the Commission. However, they cannot at this stage be placed before the chairperson due to the fact that the Commission is attending to matters relating to inter alia authenticity of those documents, the claims of confidentiality, and other matters. We are mindful of the fact that where the authors of the reports and those who commissioned them have placed them out there for the public to be able to access them online, even though they are marked private and confidential, the Commission may argue that those persons have waived their rights to privilege, and we refer in this regard to the decision of the Supreme Court of Appeal in Competition Commission of South Africa versus ArcelorMittal, SA Ltd, 680-12, 2013, ZASCA, 84, 31 May 2013, at paragraph 33, where the court, when dealing with the issue of this related to litigation privilege, waiver may be expressed, implied or imputed. It is implied if the person who claims the privilege discloses the contents of a document or relies upon it in its pleadings or during court proceedings. It would be implied too if only part of the document is disclosed or relied upon. For a waiver to be implied, the test is objective, meaning that it must be judged by its outward manifestations. In other words, from the perspective of how a reasonable person would view it. It follows that privilege may be lost, as the English courts have held, even if the disclosure was inadvertent or made in error. Imputed waiver occurs when fairness requires the court to conclude that privilege was abandoned. We quote these remarks because we are going to say those remarks, they apply equally to the reports that are available online, but marked privilege, private and confidential. Where the Commission is not getting cooperation in relation to those reports, it will use them on the basis that privilege was abandoned when they were published online. Those reports will be mentioned in my presentation, but the findings thereof will not be dealt with. The contents thereof will be referred to only to a very limited extent to demonstrate the need to call for them from those who commissioned those investigations and to show the need to further investigate as this commission. There will be reports that are relevant to the work of the Commission. They are in the public domain and are readily accessible. Those reports will be mentioned herein, but their status will be regularized in due course. There are also, Mr. Chairperson, there are also research reports that are in the public domain, which will be mentioned but not dealt with herein, simply because they do not fit within the provisions of Rule 6.5 of the rules of this Commission. There might be an exception in this regard, namely a report compiled by the People's Tribunal, because it appears that the tribunal received viva voce evidence, but also relied on research. The tribunal will be engaged with a view of obtaining the evidence in terms of Rule 6.5 of the rules of this Commission. Rule 6.1 of the rules of the Commission provides that the Commission may receive any evidence that is relevant to its mandate, including evidence that might otherwise be inadmissible in a court of law. It further provides that the rules of evidence applicable in a court of law need not be strictly applied to the determination of the admissibility of evidence before the Commission. Although the rule is permissive, the Commission is doing its best to ensure that constitutional rights of those that may be affected are observed in dealing with the documents and the reports submitted. There are several institutions that have investigated. These would include the departments, it would include National Treasury. They have investigated these issues relating to state capture, and they've produced reports that have direct relevance to the work of the Commission. But those reports are not available at this point. They will be placed before the chairperson when they have been submitted to the Commission by the entities that had commissioned them. All the reports, including those of the Public Protector and the parliamentary committees, will be submitted for the following reasons. 1, to report their existence. 2, to request the chairperson to admit them provisionally. And 3, to request that it be recorded that those reports and documents submitted, they are what they purport to be. I will accordingly apply at the end of the presentation for their provisional admission and the recordal that they are indeed what they purport to be. Thank you, Mr. Chairperson. Now I move on to do the presentation that will highlight what reports are in our possession and what the nature of those reports is. Thank you. Then we start off. I beg your pardon, Chair. I just want to open from here. Thank you. We start off by outlining presentation on the reports submitted to the Commission. That's what we have in the first slide. And then the second slide, we have the Public Protector in the center, and we have the institutions that are referred to in the report, which is the South African Broadcasting Corporation. We have Denel, we have Eskom, we have South African Airways, and Transnet. In the next slide, we deal with the overview of the reports. I think it is important to mention that the report of the Public Protector is available online, and it consists of 355 pages. This was received from the Public Protector on the 13th of April, 2018. The record, that is the record that would go with the report, was also received from the Public Protector in sealed boxes containing documentation, transcripts, and voice recordings, interviews, and 2 DVDs sealed in a bag under the affidavit of Mr. T. Ngwako, an IT support manager. Those were also delivered to the Commission. The Public Protector reported on an investigation into alleged improper and unethical conduct by the former president and other state functionaries relating to alleged improper relationships and involvement of the Gupta family in the removal and appointment of ministers and directors of state-owned enterprises, resulting in improper and possibly corrupt award of state contracts and benefits to the Gupta family businesses. The next slide deals with the report. I think I might have skipped. I beg your pardon, Mr. Chairman. Must I go back? I think I have to go back. I beg your pardon. Forward. Thank you. And then we're still dealing with the overview of these reports. And then the next reports that we put up, these are the reports that are marked confidential and private. Chairperson would observe that the first one would be from Waxman's report on the 1064 locomotives, acquisition of the 1064 locomotives for Transnet General Freight Business Inquiry Report. It has 117 pages, and the investigators are in the process of regularizing this report before it can be utilized fully by the Commission in its work. And then the next one is that of Mcebisi Jonas attorneys, which is referred to as the MNS report. It also relates to the 1064 locomotive transaction, and it's dated the 5th of June 2018, I beg your pardon. It's 144 pages. Similarly, this report is marked private and confidential, and the investigators are also attending to regularize its status. Then the next slide is the overview of the report still, where we make mention of the ENS forensics report on Friede Farm, which is one which my learned friend, Mr. Pretorius, has referred to as commonly known as the Estina project. The final report on the investigation on the Friede Farm project by ENS is dated 11 February 2014, and it's 60 pages. We have the reports from the Portfolio Committee on Public Enterprises and Department of Home Affairs. These documents, committee minutes, transcripts of the proceedings on state capture that took place before the Portfolio Committee on Public Enterprises, Department of Home Affairs, inquiry into Eskom, Transnet, and Denel, the inquiry into Home Affairs related to inter alia granting of citizenship to non-South Africans, These reports were received by the Commission from the House Chairperson, Parliament's Oversight Committee, Mr. C.T. Frolick, on 17 May 2018. Then the next slide. I'm not as good as my learned friend, Mr. Pretorius, in this. Then the next one is, it deals with this is an overview of research projects. Mr. Chairperson would be aware that there's quite a number of documents out there where individuals, NGOs, interested parties, civil society have done their own investigations on this whole concept of state capture, and they've produced reports. And we mentioned them here, and we've got the PARI reports, Public Affairs Research Institute, that's commonly known as PARI. There's 3 reports. The first one being Betrayal of the Promise, How South Africa is Being Stolen, State Capacity Research Project dated May 2017, 72 pages. It looked into Transnet, into Eskom, Denel, and South African Airways. And then the next one is also from PARI, entitled Evidence for the People's Tribunal on Economic Crime, State Capture, the Case of Denel and VP Laser, dated January 2018, and is 33 pages. It also looked into Transnet, Eskom, Denel, and South African Airways. The next one, Eskom Inquiry Reference Book, version 3, it's 26 pages, that looked into Eskom. And then we have Transnet Inquiry Reference Book, version 1, 36 pages. It's also related to Transnet, and all of these reports are available online. We have also, still under research projects, a report from Bishop Mpumlwana, South African Council of Churches, which is entitled Unburdening Panel. And the SACC conducted some research into state capture, and its findings showed at least 7 ways the scheme to loot state resources has been executed in South Africa. This report too is available to the public online. And then the next report, which already we've intimated to this one, where we are dealing with PARI reports, from the People's Tribunal on Economic Crime, dated 7 February 2018. They investigated, inter alia, allegations of state capture involving Denel and its associated companies in the acquisition, distribution, and manufacture of arms and ammunition. The members of the panel are retired Justice Zek Yakub, retired Judge Navi Pillay, Ms. Mandisa Kyanki, Mrs. Alison Maynard Gibson QC, and Mr. Dinga Sikwebu. The tribunal, in its preliminary findings, recommended, among others, a full investigation into corruption and state capture. Then we deal now with the Public Protector's report and what had prompted that report, because that is necessary as to form the basis for all the documents that are going to be placed before the chairperson. The Public Protector had received 3 complaints, one from Father S. Mayebe on behalf of the Dominican Order, and from Mr. Musi Maimane, a leader of the Democratic Alliance, and a member of the public whose name was withheld. In analyzing the complaints, the Public Protector grouped the investigation into 1, alleged breach of the Executive Member of Ethics Act 1998, awarding of contracts by certain organs of state to entities linked to the Gupta family, and the Public Protector has made adverse findings against certain individuals, persons, and entities as reflected in her report. The 2-phased inquisitorial investigation process to accommodate the time and resource limitations by addressing the pressing questions threatening to erode public trust in the executive and also SOEs. That's what the Public Protector phrased the nature of the inquiry that she adopted. In phase 1, she did not touch on the award of licenses to the Gupta family. She superficially touched on the state financing of the Gupta-Zuma business while only selecting a few state contracts. The process for phase 2, which is the final phase of the investigation, was mapped but not undertaken. In paragraph 4.21, the Public Protector indicated that the investigation into Denel will form part of the next phase. At page 337, paragraph CCC, the public protector stated that the investigation into the conduct of the Bank of Baroda in relation to the purchase of all shares in Optimum Coal Holdings by Tegeta and the Rehabilitation Fund had not been evaluated by her and would form part of the next phase of the investigation. Then, Mr. Chairperson, we also would like to refer you to page 351 of the Public Protector's report, where she indicated that she intended to investigate in the next phase whether any state functionary in any organ of state or other person acted unlawfully, improperly, or corruptly in connection with exchange of gifts in relation to Gupta-linked companies or persons. As part of the remedial action listed at pages 353 to 354, the Public Protector recommended that the President appoint a Commission of Inquiry headed by a judge solely selected by the Chief Justice, who shall provide one name to the President. This commission then was established in compliance with her remedial action. That state capture report has attached to its supporting documents. These are not all documents because of the nature in which they were submitted to the commission. We still need to paginate and index all of the documents before you can submit the original, the copies of the originals. But we mentioned some of the exhibits that have been attached from exhibits 1 to 27. Exhibit 27 has 3 annexures: the transcripts of the reports, hearings between the Public Protector and the former President, Mr. Jacob Zuma, on this dated the 6th of October 2016, which is 89 pages. We also have transcribed interviews of Mr. Rob Davis and Mr. Fikile Mbalula. We have voice recording of the conversation between the Public Protector and Mr. Pravin Gordon. And we have transcripts which are dated 9 September 2016 of the following persons: Mr. Mcebisi Jonas, Mr. Ndleleni, Mr. O. Mhlana, Mr. Themba Maseko, Ms. B. Hogan, Ms. Mcebisi Mentor, Mr. Jacob Zuma, Mr. Julius Malema. Then we move on, Mr. Chairman, to the Portfolio Committee on Public Enterprises. We've already mentioned this inquiry into Eskom, Transnet, and Denel between the period 17 October 2017 to 27 February 2018. The Portfolio Committee on Public Enterprise has also provided information, the transcripts from day 1 of the proceedings, 17 October 2017, but there were just 2 transcripts for 2 days that were not attached to the bundles, and those have been requested by the Commission from Parliament. And those days is 16 and days 16 and day 19. We also list in the previous slide the number of pages each transcript consists of. Then following that, Mr. Chairperson, is information provided also from Parliament, from the Portfolio Committee on Public Enterprises. There are statements that were made to that committee. Those statements have also been made available. The statement from Ms. Dudumieni, statement from Ms. Musilo Mutepu, a statement from Mr. Abraham Masango, statements from the Deputy Minister Ben Martins, statement from Dr. Baldwin Ngubane, and statement from Dr. Zweli Mkhize. We also received other statements from DTI. I will simply mention the names of the persons that had given the statements from DTI, Eskom, Exaro, G9 Consulting Services, Minister Lynn Brown, Minister Gigaba, Minister of Public Enterprises, Mr. Anoj Singh, Mr. Brian Molefe, Mr. Koko, Mr. Linnell, Mr. Tsepo Lakimuntana, Mr. Koma, Ms. Suzanne Daniels, Mr. Zola Tsotsi, Ms. Bianca Goodson, Ms. Erica Johnson, Ms. Venele Klein, Ms. Viroshni Naidu, Mr. David Robert Fine. We also have submissions from the EPPF, from ESCOM Inquiry Reference Book, from Weber Wenzel representing Ms. Bianca Goodson. We have Section 34 report from Piers Marsden. We have ABSA statements on Tegeta, dated 17 November 2017. I beg your pardon. We have ABSA statement on Tegeta, dated 17 November 2017. Then we have the inquiry by the Portfolio Committee on Home Affairs into the naturalization of the Gupta family. Those transcripts, we've listed them from the 27th of June 2017, another transcript of the 22nd of August 2017, another one 27 February 2018, and 6 March 2018. On Home Affairs, the Portfolio Committee also received documents which were, thank you. The report on granting of naturalization to the Gupta family, Mr. Rajesh Kumar Gupta, Arti Gupta, Mr. Atul Kumar Gupta, Chitali Gupta, Shashank Singala, and Shrikant Singala. There were reports on granting of naturalization to the Gupta family. The relevant acts like the South African Citizenship Act were also attached to those reports, and the Aliens Control Act of 1991 was attached. The Department of Home Affairs Standard Operating Procedures on Citizenship, dated August 2016. A list of names of persons granted early naturalization applications for 2013, 2014, and 2016 in terms of Section 5, subsection 9B of the South African Citizenship Act of 1995 were also attached. Agreement between the Government of the Republic of South Africa and the Government of the Republic of Indonesia on visa exemption for holders of diplomatic, official, and service passport, tabled in terms of Section 231(3) of the Constitution. Also, documents submitted by the Gupta family and or related entities on investments and charitable contributions. Then we tried to, according to the record and the information received, try to create ticks of what documents related to each individual within that family, and we have done that in accordance with what the Portfolio Committee's evidence was, which shows who had details of the travel particulars, application for temporary residence permits, application for work permits, applications for an extension of validity or renewal of an existing permit, permanent residence applications, immigration permits, application for certificates for naturalization. The Portfolio Committee had listed and tabled the names of the persons that were granted early naturalization in terms of Section 5 and those that related to the Gupta family. And they are listed there as Mr. Gupta Angori, Gupta Shivani, Singala Kamal Kant, Singala Surai Kant. Then we move on then to the final report on investigation onto the Vrede Farm project, which was compiled by ENS. In August 2013, National Treasury's Specialized Audit Services co-sourced ENS to assist with the investigation allegations of procurement irregularities allegedly committed by the Free State Department of Agriculture and Rural Development in procuring the services of Estina Paras Dairy. ENS obtained information regarding the project and interviewed witnesses from various departments. They also highlighted limitations in their investigations, being that they encountered lack of cooperation from some of the state employees and the fact that they were not placed in possession of some of the documents they requested. So that then will necessitate an investigation into that project. Then the final report, in the next slide, we deal with what they say in the final report, where we outline as to who had commissioned the report, being the National Treasury Chief Procurement Officer, and that we deal with briefly what the investigations related to and the structure of the report that they have put up. And in paragraph 4 of that, in relation to the structure, ENS explained that the purpose of the report was for National Treasury to obtain clarity on the principal role players who participated in the conduct under investigation, to be furnished with an indication of the total funds allocated to the project, understand what funds had already been expended on the project, appreciate whether or not it was likely to receive value for money in the project. And their preliminary observations were that they had constraints relating to the information that the investigators were able to access due to lack of cooperation from the department. And then, and then we also in paragraph, in the next slide, we deal with the key findings of the final report onto the Freire Farm project. They have highlighted non-compliance with procurement procedures. The deviation from the department's supply chain management policy was contrary to the PFMA, according to them. It remained unclear to the investigators whether Paras was actually involved in the project. They say at the time that the HOD signed a contract with Paras on or about June 2012, the Agri-BE entity named Mohoma Mobung Dairy Project, under whose auspices the Freire Dairy Farm was to be established, had itself not been formed yet. The Mohoma Mobung Dairy Project was only established on 11 October 2013. They deal with the existence of a 99-year rent-free leasehold agreement, which was purportedly concluded but remained unsigned between the department and Estina. The investigation team was not able to establish whether Estina made any financial contribution towards this project, or if they objectively, as in ascertaining that Estina actually invested any funds in the project. Then, in the next slide, they make their recommendations that disciplinary steps be taken against certain officials, advising the National Treasury to obtain legal opinion on the consequences of the cancelling of the contract with Estina and of setting aside the 99-year rent lease agreement, conducting a detailed financial analysis into the finances of certain officials, that no further funds be invested in the Freire Farm project. It is not clear whether any of these recommendations had been acted on. In addition, the subtext of these recommendations is that a full investigation should be conducted into the project. Other than the National Treasury that commissioned the report and the Office of the Public Protector, we are not aware of any other commissions, tribunals, or court or bodies before which this report was placed. The National Prosecuting Team has made the Commission aware of the charges that it wished to prefer against 11 individuals and entities who were involved in the Freire Farm project. As indicated above, the public protector has investigated the Freire Dairy Farm. That report has not been formally made available to the Commission at this stage. Then the next report is a report compiled by Jeff Butlander SC, who was appointed by Mr. TMG Sekhwale, an independent non-executive chairperson of Trillian Capital Partners Pty Ltd, towards the end of November 2016, to conduct an investigation into certain specific matters. Mr. Sekhwale acted on the authority of a resolution of the Board of Directors, allegations in the Sunday Times of 23 October 2016 with regard to Trillian and related persons and entities, and issues that raised in the report of the Public Protector in the State of Capture report in relation to the conduct of Trillian and related entities. In conclusion, Butland SC stated at paragraph 172 that this investigation is still incomplete. It is necessary for these matters to be investigated by an entity which has the power to compel all concerned to give evidence and provide documentation. In my opinion, the most appropriate entity would be a commission of inquiry established under the Commissions Act and undertaken by a person or persons of independence and integrity. So that report 2 indicates that the parties would want those matters investigated by this commission. And then the allegations with regard to the Trillian group of companies as annexures that formed part of the Butland report. Thank you. Then those are just listed as annexures, and we'll simply just read out what was there. The Trillian Group organogram, the letter of the Department of Public Enterprises, Trillian invoices between Trillian and Eskom, McKinsey and Company letters to Eskom, McKinsey and Company letters to Trillian, Trillian invoices, outsourcing engineering consultancy service agreements between Trillian Management Consulting and eGateway Global Consultants, dated 26 January 2016, and we list the invoices and we list the amounts that were involved in those invoices. Then the next report is the Waxman's report, which we have mentioned earlier when we were dealing with the overview of the reports, which deals with the acquisition of 1064 locomotives for Transnet's general freight business. We mentioned how that report came into being, that the report itself is dated the 24th of November 2017 and is entitled Acquisition of 1064 Locomotives for Transnet General Freight Business. It is usually referred to as the 1064 locomotive acquisition. This report was commissioned after the Board of Directors of Transnet mandated Waxmans Incorporated to advise and prepare a report on, among others, the allegations of impropriety leveled by the economic freedom fighters against it in relation to the acquisition of the 1064 locomotives. Waxmans was mandated to look into the procurement processes to identify all persons, companies, and timelines involved in the procurement process, their role and relationships, to review, verify, and validate the submissions made to the Acquisitions and Disposal Committee, ADC, and the board, to ascertain the reasons for the increase, if there was any, in the estimated total cost and whether it was reasonable or justified to conduct interviews, to investigate the existence of a certain contract between Tequesta and CSR Hong Kong, investigate whether prices were inflated after hedging, and determine whether contingencies and escalations were added, establishing what governance processes were employed in implementing the transaction and appropriateness thereof. Thereafter, Waxmans was mandated to make findings, recommendations, and possible actions to be taken, and recommendations also on preventive measures. In its report, Waxmans released as a sequel. In fact, we just highlight what are the issues that the economic freedom fighters had raised in their pro forma charge against the board of Transnet, that there was allegedly an amount of 17.4 billion taxpayers' money that was lost in inflated prices on the purchase of 1064 locomotives, that they allege that the money was lost to corruption during the procurement of the locomotives. They also allege that the EFF2C had pointed fingers at the various people as having influenced the process, and that the accelerated delivery schedule and the increase of prices and benefits was to certain persons, and then the dossier also implicated certain companies in corruption. Attached to the Waxmans report, there is another report which is referred to as the forensic audit report. And Waxmans, in its main report, suggests that those reports should be read together. They indicated that there were certain challenges that they encountered that they encountered in their investigations because they could not consult with key witnesses, which they listed in their report. They also had requested some documentation which they could not be furnished to them. And in paragraph 13.7 of the report, Waxmans stated that based on the facts raised by its investigators, a judicial inquiry with prosecutorial and inquisitorial powers, with powers to compel witnesses to provide documentation and oral evidence, would be the best body to do the investigations. It is accordingly necessary for this commission to conduct further investigations into the transaction for the acquisition of the 1064 locomotives and other matters related thereto. The relevance of the investigation evidence obtained therefrom and the witnesses who testified or made submissions to the commission would be relevant to paragraphs 1.4, 1.5, 1.6, and 1.9 of the terms of reference. Due to the fact that the commission is in the process of first obtaining permission to use the report, establishing its authenticity, and conducting its own investigations on these matters, and to follow due process in identifying implicated persons and or witnesses, the chairperson is simply being alerted to the report at this stage in accordance with Rule 6.5 of the Rules of the Commission, and to enable the Commission to secure relevant transcripts, if any. The next slide deals with the MNS report, acquisition of 1064 locomotives for Transnet General Freight Business. This report was commissioned after the Waxmans report was submitted to the board of Transnet. The board resolved that the Waxmans report was inconclusive. On 20 February 2018, the board appointed MNS to conduct further investigations into the alleged irregularities relating to the procurement and award of the 1064 locomotives tender. MNS was given the scope of its work. It made several findings. MNS engaged the services of Fundudzi Forensic Services. The report is marked confidential, and we do not wish to deal with the findings at this stage. However, it is important to highlight that there is a need to conduct further investigations into the 1064 locomotives transactions, because upon the reading of the MNS report, it is apparent that one, that this commission must investigate the circumstances under which the board approved the transaction as negotiated. Two, that the commission will be able to use its powers to demand access to the file that is allegedly hard-coded, which MNS could not access. They say so at page 108 of their report, paragraph 5.4.2. That file, I beg your pardon, that file may enlighten the commission on the purchase costs, which will have a bearing on the calculations and projections made by MNS. If the external audit was conducted as recommended by MNS, the commission will have regard thereto when conducting its investigations. The commission will also be able to interview all relevant and key officials before making its findings. By so doing, the commission will be fulfilling its mandate in terms of paragraphs 1.1, 1.4, 1.5, 1.6, and 1.9 of the terms of reference. The next report, this deals with the research projects. I've already mentioned these, the PARI research documents, and we have highlighted what they are, the number of pages. And that of Bishop Mpumlwana, we've already dealt with that, and the People's Tribunal on Economic Crimes. And lastly, the article by Professor Peter Labuskachne on patronage, state capture, and oligopolistic monopoly in South Africa, which was published in 2017. That is the end of the presentation, Mr. Chairman, but now I wish then to, as promised, hand up the documents. The first being the Public Protector's report. I beg leave that these be marked A, so that all the documents that we will be, and the reports that we'll be handing in to the Commission, if it pleases the chairperson, to reserve alphabet A for all the reports. I beg leave to hand up the 355 pages report of the Public Protector as Exhibit A1. I have brought a marker as well for your convenience.
Thank you very much.
Thank you.
actually, okay. You may mark it.
Yes.
You can already mark it from there.
Or from here.
Yeah,
Yes, thank you.
before you hand it. No, the next one.
The next one.
Yeah, if
yes.
there's a next one,
Thank you very
she can mark this one. Yeah.
Thank you. That will be A1. Okay. I have here a copy of all the documents. There's about, I think, over 122 boxes of documentation, which we are currently paginating. But
Yes.
those documents are contained in this disc. We had
Yes.
received an original. We made a copy for the chairperson.
Yes.
But once all the pagination has been done,
Yeah.
the original will also be presented to the commission. I beg leave to hand up this disc and that it be marked Exhibit A2.
Okay.
Thank you. Just put in exhibit. Thank you. Thank you. And then if it pleases the chairperson, I'll simply, I'm not sure, it's not particularly necessary because the case is available.
I
But
wa-
to
I wonder whether it might not be more convenient if you were to mark all of them
and then simply
and then
hand them
just-
up.
and that's handed up with a list, a notice that says these are the reports that are attached, and then we just read into the record
What
what
annexure
they are.
A1 is.
Yeah,
Well,
yes.
I will do so.
That might be faster,
Thank you.
which could be done if it's convenient, even tomorrow morning, if you need the time to mark them, or
Yes.
unless
There
marking
are
them
not
is-
too many, Mr. Chairman.
Oh, okay.
There are not too many.
I
If
thought you
an
were mentioning
adjournment.
100 or something.
No,
Okay.
we didn't bring those boxes because,
Oh,
yes,
okay.
no, because they are still being
Oh, okay.
paginated.
Then
yes.
you may proceed then. If it's convenient to do them
To
now,
do-
because there are not many, that's fine.
As chairperson, please. Sorry. And then the next one, although it's not really necessary to make it an exhibit, but because I had mentioned that as one of the foundational documents, which is the case from the Gauteng division, that would be exhibit A3. If it's not really, that is the judgment.
Well, you said the A would be reserved for reports. Why don't we keep the judgment as something else?
Yes, maybe we can just send it up as a judgment without giving
Yeah,
an
we can
exhibit
just
number.
say judgment,
Okay.
yeah. Whenever anybody refers to it, we will always know.
As that is the judgment that
Yeah.
we're talking about. And then I would beg leave to hand up the inquiry into ESCOM by the Portfolio Committee. It's dated, it's day 8 of these. These are all the proceedings. But what I will do, will simply give them one number because they emanate from the proceedings that relate into the public enterprises and home affairs. But the one for home affairs, we will mark it Exhibit A3.
But are
These are
they all one report comprising different volumes?
they differ.
Because
Yes.
if they emanate from one body,
Yes,
a particular portfolio committee, for example,
yes,
but they deal with different issues, entities, it's better that you should
we give them one
give them different
numbers.
Yeah.
Okay, thank you, Mr. Chairman. Shall we mark them then? These will be Exhibit A4, because there's 3 volumes. It will be A4A, if that is not going to be confusing, and then A4B. A4B would be the one that deals with public enterprises. A4A deals with home affairs. A4B. A3. I beg your pardon, this will be A3. A3A. So this is A3B. I beg leave to hand up A3A, A3B, and A3C. Okay. These are all from the Portfolio Committee on Public Enterprise Investigations and Home Affairs.
Thank you.
Yes, thank you. Thank you. Mr. Chairman, as indicated earlier, these reports are handed up and they are what they purport to be, and they are handed up for your attention. Thank you.
These reports are provisionally admitted, and their status is that they are what they purport to be. Thank you. Mr. Prejudice?
The efforts of Advocate Norman are appreciated, but it's been pointed out to me that this is just the first of a large number of documents that will over time be presented before the Commission. And we should perhaps at this stage devise a system for index pagination and keeping a proper and comprehensive record together with an index, not only in regard to reports handed up, but separately in regard to all the presentations made orally before you. And if you would leave that to us, we will come back to you, Mr. Chair, with a comprehensive system of index pagination and index of proceedings as well.
That's in order.
Thank you.
Thank you. Where does that put us in terms of today?
By your leave, Mr. Chair, Mr. Mathebula will be, or has been arranged to be present tomorrow. And so if we may adjourn until 10 o'clock tomorrow morning.
Okay, thank you very much. We will then adjourn today's proceedings and resume tomorrow at 10 o'clock to hear the evidence of the first witness. Proceedings are adjourned.
All rise.